so you've been very busy in this field, and you have a lot of experience on this topic, which is exactly why I wanted to have you on to talk more about a couple of developments, starting with a new ruling out of Texas in federal court that strikes down the felony indictment gun ban. To this point, the Federal Firearms Act had prohibited people who were indicted for felonies from receiving firearms while they were under indictment. Judge Counts, in this case, determined that there was not a historical analog that he could identify, which would give credence to this restriction under the new Bruin standard. So can you just give us your first reaction, maybe explain a little bit of the implications of this particular ruling?
So federal law prohibits a number of people within a number of categories from even possessing a firearm. And so these are, the felon in possession ban is the most commonly known. There are some others, such as the misdemeanor domestic violence ban, and people who are unlawfully using drugs, and so on. In addition to that, federal law has a prohibition that says those who are under indictment for a felony may not receive a firearm, but they may continue to possess firearms that are already owned. And so these are individuals who a grand jury has found probable cause to believe that they've committed a felony and they're heading to trial. And so they're in this kind of in-between status that they can't receive a firearm, they can't transport a firearm in interstate commerce. But they can possess and presumably carry it within their home state, subject, I suppose, to any restrictions that are placed on them as a condition of bail.
Yes, it's kind of it's an interesting derivative of the felon in possession ban, because it's applied to people who haven't actually been convicted of anything yet, although they are going through the court process. But
they are. And convictions,
and that does come up as a distinction in this ruling, right?
Yeah, no, I mean, it's definitely, it's kind of intermediate state that they are awaiting trial or in trial. If they are convicted, they will lose their gun rights under federal law. The Supreme Court has assumed, although not with any real justification, that the felon in possession ban is constitutional. It has repeated those assurances, even though there are no historical analogs to that. Those were 20th century creations that, depending on exactly when you want to date it, you're either from the 1930s or 1962 or maybe 1968, a couple dates that, can be floated around depending on exactly which law you're referring to. But there's no analog in the 1700s or 1800s. And so they're kind of in this middle ground, and federal conviction rates are famously high. So most of the people who are indicted will in fact be convicted or plead guilty and will lose their gun rights. But while they're in this middle stage, they can possess but not receive.
Right. And I guess in this case, the defendant had, he lied on the background check form. That's what he was ultimately actually convicted of. Because he was under indictment when he bought his firearms, but he hadn't yet been convicted, and so. But I don't know. Do you? I guess one question I got on Twitter was actually, do you think the judge went too far in even deciding the legality of the Federal Firearms Act when the actual crime was lying on the background check?
Well, there's also a materiality question of whether it's not a crime just to lie. The statement has to be material. And so I don't think he went too far in doing that. But I don't think he went too far in looking at it.
Okay. Yeah. So that's important. Like, he's not necessarily going well beyond what the scope of the case is.